this court of appeal first district know, anyone having business with this court, draw near, your attention shall be heard. The United States of the United States, State of Florida,
Be seated, please. We have a short docket of 3 cases today, but we will take a break after the first case. We'll have coffee made in the attorney commons, and we invite you to join us in the commons to your right. First case today is a petition for writ of certiorari, CSX Transportation versus Columbia Grain. Appellants.
Good morning, Your Honors. Mike Tanner of Holland and Knight for the petitioner, CSX. And I'd like to reserve 4 minutes of my time for the rebuttal. May it please the Court, the order below departed from the requirements of law in 3 respects, and it injures CSX in a way that this Court would not be able to review and remedy on appeal. It departed from the requirements of law first, in that it followed an ex parte conversation between counsel and the trial court, and although the respondent characterizes that in their papers as an in-camera review, we submit it was clearly ex parte. Secondly, on the trade secret issue, the trial court made findings that the material that was requested by CSX made findings that those were trade secrets, but he did so without any record. There were no depositions, affidavits. There was no evidentiary hearing. He didn't review the material.
Let me ask, could there be any doubt that the rates charged by a competitor to a common customer is a trade secret?
We have no quarrel with that proposition in general, Your Honor. We quarrel with the fact that no showing of that was made.
I see.
And the trial court concluded then and made a finding in his order that it was a trade secret, and indeed it appears, I think a fair reading of the order, is that he put the burden on CSX to show that the material was not a trade secret rather than putting it on the proponent of the privilege, the respondent here, which the Eastern Cement case required him to do. So in that respect, clearly we submit the trial court departed from the requirements of law in disposing of the trade secret privilege claimed by the respondent. Thirdly, the trial court made yet another finding without a record, and that is on this issue of whether the alleged oral agreement was exclusive or non-exclusive. Again, no depositions, no testimony, no affidavits, and yet in the order there is a finding that it was a non-exclusive contract, and we find that remarkable, first because there were no allegations by the respondent that it was non-exclusive. They didn't plead it in their complaint or file a reply, and we think that was clearly a matter in avoidance. It came up in argument before the trial at the hearing, and it was simply argument of counsel.
If we say that that's error, why is it irreparable on appeal?
Well, effectively what the trial court did is grant summary judgment on the mitigation defense because he precluded any ability for us to obtain the information necessary to develop the mitigation defense. And therefore, Your Honor, there will be a hole in the record. There will be an absence in this record of what the mitigation information would be, and there will be nothing for you to review on plenary appeal. So you won't be able to review it and fix it on plenary appeal.
That sort of, when you read this case, that does jump out a little bit. I must say it looks like the trial court may have granted summary judgment, maybe inadvertently, I'm not sure, because it was in the course of making a finding on whether the sought materials were relevant. But that's an interlocutory decision, and the trial court's free to revisit that at any time, as I understand the law. Isn't he?
Well, certainly he is, Your Honor, but I think a fair reading of this order is that the court decided that material would not be discoverable, and he gave no indication in the order or otherwise that he would plan to revisit.
I'm talking now, I understand on the discovery, but I'm talking now about your claim of being foreclosed on the mitigation defense.
Right. Well, the mitigation defense is a derivative of that material. I mean, our position is that they claim that they were injured by this but because they didn't get the economic benefit of this rate spread agreement that they allege existed. Well, if they were able to go out into the market and get rates with another carrier that were as good as or better than what they could have gotten with CSX, then we submit that clearly is an issue in mitigation that the court needs to consider and should consider and would be a matter to review. But there won't be anything in the record on that.
Well, it seems to me what the trial court did is maybe not go as far as, in effect, grant summary judgment, but did hold that the mitigation defense would require Columbia Grain to take actions that were unreasonable, applying a standard in the restatement. It seems to me that's a little different. Why isn't that a valid basis for denying discovery?
Well, you're correct. He did do that, and we quarrel with that for two reasons. Number one, he did it again without a record. There's nothing in the record, factually, testimony, affidavits, what have you, to support that finding. It was simply argument of counsel. And if you look at the Burger King case and the Massey case that were cited by the court in the order, those are clear that the court, if it's going to make a finding that an agreement is non-exclusive, it must do so on the basis of a record. In the Burger King case, for example, there was actually a written agreement that the court had before it and was able to make a finding of non-exclusivity based on a written agreement. And in the Massey case, there was a finding made at the pretrial conference. We didn't have anything of the sort here. We had no testimony or evidence of any kind in the record other than the argument of counsel on which the finding was based. So we contend that was error. And so in those three respects, then, we think it's clear that the trial court departed from the requirements of law. That is, it followed from an ex parte conversation, albeit characterized as in camera. He didn't follow the rules on trade secret.
On that one point, even if we agree that it was an ex parte hearing, why wasn't that one procedural defect harmless error? If we look at and if we address all of the other various issues you're raising about lack of any record evidence for the substantive decision. Well,
I would say the Supreme Court heard the same argument in the Rose case. The party there who had been involved in the ex parte conversation with the trial judge on a motion for post-conviction relief said essentially the same thing, Your Honor, that yes, there was an ex parte conversation, but later on the other side was made aware of it and was given an opportunity to comment to the trial judge. And the Supreme Court in the Rose case said it doesn't matter. What we're dealing with is the appearance rather than the fact. And so that so tainted the order, the Supreme Court said in Rose, that alone was enough to require the court to reverse that order.
I'm sorry, did you see pages 25 to 28 prior to the judge's order coming out?
I'm sorry, sir?
Prior to the judge's order coming out, did you see pages 25 to 28, the ex parte hearing?
Yes, sir, we did. I believe we did. Yes, sir.
Did he give you an opportunity to comment on what?
No, sir. What he gave us was an opportunity to submit an order. The respondent submitted an order. We submitted an order. And
so you were never given an opportunity to inquire further or to offer any kind of rebuttal to what was said? Or
we were not.
To address in any way what was said?
That is correct, Your Honor. And we would have certainly rebutted and had quite a bit to say about that post-remedial measures example that the trial court gave in the ex parte hearing, because we submit that as completely off point with the facts of this case. And apparently that was in the trial judge's mind when he ruled. And we would have liked an opportunity at the hearing to address why that was completely inapposite. And so we submit that for those three reasons, trade secret issue, the ruling on non-exclusivity, both of those without a record, and then the ex parte character of the conversation render the order a departure from the requirements of law. We submit it cannot be reviewed and remedied by this court on appeal for the same reason that the courts so held in the Stewart case, which was a decision of this court, albeit another panel, the Hill case, the Carroll case, and the Ruiz case. In all of those, the common thread was that the order had foreclosed the ability of the litigant to get any information on a key point. And therefore, there would be an absence of evidence on that, a hole in the record, if you will, so that the court couldn't review it on plenary appeal. And we submit that's the situation here. We would ask the court to quash the order, review it, and follow what the court did in the Best Technologies case, where there was an asserted trade secret. The court, the appellate court there, remanded with instructions to disclose the information pursuant to a protective order.
Well, if we agree with you in terms of what we do on remand, Since most of your argument is concerned with a lack of record evidence to support findings by the trial court, shouldn't we send it back to have the more fully developed hearing so that any decision by the trial court will have an adequate record?
I think that would be an appropriate disposition. I think that's right. But I think once the trial court goes through the proper procedure on trade secrets and makes a finding, if he does, that it is in fact a trade secret, then the Best Technologies case would permit him to disclose it under the protective order. If there are no further questions, I'll stand on our papers and be back on rebuttal.
Thank you, Mr. Skinner.
Thank you.
May it please the Court. My name is Kyle Gavin with Lyles, Gavin, Cosentino, and George, and I represent Columbia Grain in this matter. First, if I may point out a practical matter here, that this issue really has little to do with mitigation, and I'll describe why in a minute, but it has a lot to do with preventing competition in North Florida between rail carriers. If mitigation was really the key in this case, and our worthy opponents in this case are certainly know what they're doing, but they would have what we subsequent to the hearing, we learned that they already knew that negotiations were going on. That's why we immediately expedited the transcript, provided it to CSX before they submitted their proposed orders, and indicated to counsel that if they needed to respond to anything that was said, that they should. But at that point, we decided, well, apparently the cat's out of the bag. Maybe this wasn't the trade secret we thought. We fully believed at the time that whether or not there were negotiations going on, whether or not an agreement had been reached, that those issues were trade secret. The reason I say competition in North Florida, Columbia Grain has a facility outside of Lake City in North Florida. And it was those negotiations that were just beginning that we were trying to protect, because if the railroad, the competitor, got that information, the railroad at that time could reduce their other rates in the area to keep that competition from happening.
Are you saying that the fact of your negotiations, not the rates from their competitor, but the fact of your negotiations was a trade secret?
Yes, sir, I am, and there are a couple reasons for that. One is that the Columbia Grains facility in North Florida, outside of Lake City in Bahia, Florida, is on CSX tracks. Obviously, if we're negotiating with their competitor, that doesn't bode well as we seek renewal with the CSX for our rates. In other words, if they know we're out there looking to possibly build on another track for the North Florida business, that could hamper our ability to negotiate with them on an arm's length basis in North Florida. So for that reason, we considered that it was a trade secret and confidential. Also, from a competitive standpoint, if that deal had been struck, we would give the railroad, CSX, a heads up on restructuring their contracts in North Florida to defeat that competition. So, and companies typically do keep confidential their negotiations. In other words, they typically, when they're negotiating something like this, a new project, they typically don't have a press release, and certainly that didn't happen here. What did happen, and what was explained to me after the hearing, was that it was, look, Kyle, CSX already knows you're talking to them, and this is why. At that point, we realized that, well, the cat's out of the bag, that we should provide the transcript of the hearing and give them an opportunity to respond if, in fact...
I don't mean to be sarcastic, but does it take a rocket scientist to conclude that you might be talking to my competitor if you're dissatisfied with the way I've been dealing with your rates?
No, sir, but...
I mean, that strikes me as just not, it's just sort of common sense.
Well...
I mean, I understand the details of your negotiation, but I would have to think that CSX would say, of course they're talking to my competitor.
Well, not really. In this circumstance, it would be if it was it was very easy to do business with your competitor. Here, in order for us to do business with Norfolk Southern, we would have to build a facility, a multi-million-dollar train receiving facility on their tracks. that is a big undertaking, as we incurred down at Lacucci. So I'm not sure that that would necessarily be the conclusion. And also, when you begin negotiations like that, particularly with a competitor, they don't want you talking about it. And that was one of the problems we had here. There were three things, in essence, that I revealed to the court. And the purpose of that was not that, at this hearing, nobody disputed the trade secret nature. If you look at the transcript talking about it, CSX went to great lengths to explain why this same type of information on their end is highly confidential. That's hardly the argument someone would make if they were trying to prove that this isn't a trade secret. And there was no doubt in anyone's mind that whether or not this was confidential information was not an issue at the hearing. Even their motion indicated that that issue was moot, meaning we don't need to discuss that. What their argument was is that we have this confidentiality order that says you can produce information on an attorney's eyes only basis. And our point to the court was, and I understand their argument that I indicated to the court the comments that the Norfolk Southern attorney made to Mr. Lyles, my partner. The problem with that is we could not get Norfolk Southern, who wanted to keep all this quiet, to come into court and file affidavits and that type of thing. We also didn't want to scare them from the table. And to be honest, we were concerned that their motive, the railroad's motive in requesting this information, was not to see these negotiations come to fruition, but was just the opposite, was to completely stop them, because they knew that Norfolk Southern would never allow them to be a fly on the wall of our negotiations through this discovery process.
Well, accepting hypothetically your argument that that there were other motives, address please the argument by the appellant that there simply wasn't a sufficient factual basis for the trial court to make the findings that basically buttressed the order.
Well, I think we first have to start out with the party seeking discovery has the burden of showing the relevance of the information that they seek. The argument, and then once the court determines that it's a trade secret, and I would submit that that was a conceded issue at the hearing, that this information is trade secret. You can even look at their argument, and they were arguing that such information was trade secret. So the court wasn't concerned whether is this a trade secret or not. Secondly, once the court determines that something is trade secret, then the standard is whether or not the party seeking the discovery can show a necessity for that information that outweighs the producing party's interest in keeping it confidential. So that was really what this hearing was about. And they submit that we had the burden of showing, proving mitigation, but that simply isn't the case. They rose as an affirmative defense the duty to mitigate. The duty to mitigate doesn't arise in the case of a non-exclusive contract. Again, the court wasn't making final rulings in the case.
But what evidence was there in the record as to whether this contract was exclusive versus non-exclusive?
Well, there wasn't any evidence in the record. It was never pled by either party, and I submit they had the burden. They're seeking the discovery. The case law says that they have to show the relevance of this information. They have to show their necessity. It's not, the case law doesn't say that the party seeking discovery has the burden of proving relevance unless the burden of proof is on the other side.
But didn't they raise the defense of mitigation?
Yes, sir, they did.
Okay, and then they say that these rates are relevant to the defense of mitigation. And the response to that is, no, this is a non-exclusive contract, and therefore there is no mitigation, defeating their defense, it seems to me. Why aren't you obligated, if a fact defeats their defense, to prove that fact?
Well, they have to prove the duty exists. The duty simply doesn't exist in a non-exclusive contract. So it's not, for example, in the typical case, it's not the defendant's burden to prove that a duty existed to the plaintiff. It's the plaintiff's burden, the party raising that issue to prove the duty. So it was, at trial, I submit it would be their burden to show that a duty to mitigate exists And they can only show that by showing that this is an exclusive contract. They failed to make that showing at the hearing.
The trial court ruling wasn't based on a failure of evidence. It was based on a finding that the contract was non-exclusive.
Well, and that finding was based on, you are correct, the lack of evidence of that. And it was their burden at that hearing to present that evidence. And I would submit that there is not going to be any evidence, once we get past this hearing, there is not going to be any evidence that Columbia Grain, that has never, that just simply evidence doesn't exist that Columbia Grain can only do business with the railroad. That evidence simply doesn't exist. So in essence, that's a false issue. I know in order to make a record, you have to go through the steps, but I would submit for discovery purposes, they had the burden of showing that. And even at trial, I do not think it's Columbia Grain's burden to prove a duty exists under their affirmative defense. I think that's their burden.
Well, they also alleged that it was part of their defense in general, to show the competitive nature of the business and why the spread wasn't exactly what you thought it should be. I mean, didn't they also make that allegation?
Yes, sir, they did. Well, they made it in their motion, not in the complaint, in the answer. That wasn't affirmative defense, but certainly in their motion, and that came up at the hearing. But the point there is, nowhere does Columbia Grain allege that CSX's failure was to maintain any sort of rate relative to competitors, to the Norfolk Southern, anyone else. The gist of this claim is that they committed to Columbia Grain that they would, with regard to their own customers and their own rates, that there would be a price spread between the volume discount for a huge unit train and these smaller shipments. That is the whole basis of this complaint, is that they then went to, right after Lucucci came online, they went to some of these other smaller shippers and started offering them basically incentives not to do business with us. And so it has nothing to do, and the court did find that there was nothing in the pleadings, and correctly so, I believe, that there's nothing in the pleadings to indicate that this case has anything to do with anyone else's rates. But your question goes back to anyone else's but CSX's rates. In other words, our complaint is, look, you're not staying in line with the Norfolk Southern. I would submit we would not, if that were the facts of this case, we would not have a case because that wasn't the deal between the parties, and we haven't alleged that. But what
you have alleged an oral contract that was based upon a spread.
A spread between CSX's own rates, their own rates.
And obviously I would think that there's some aspect of achievability in that oral agreement that you allege occurred, and if this is just part of their general defense to your allegations, you know, if there was a contract, this is what governed it, and this is the facts that show that we kept our part.
Well, what Norfolk Southern's rates are, I would submit, have no bearing on CSX's own rates relative to their volume discounts between train units and single and 15-car units. That the Norfolk Southern's, whatever rates they may be charging, would be irrelevant. And the court found that those issues had not been raised and aren't at issue. And again, we're dealing here with the balancing act that the trial court has to do between...
I'm sure I understand. CSX has responded and said, one of the reasons our rates charged Columbia Grain has changed is that market forces required us to adjust our rates so that we would not lose business with these smaller shippers over here. Why then, if that's the case, why isn't it relevant to show what the market forces are?
Well, a couple of things are at play there. Again, the court's doing this balancing act between understanding that this is confidential information and trying to determine whether CSX has a necessity for this information. And we're talking Lucucci is in Central Florida. Norfolk Southern's tracks don't go down that far. Norfolk Southern's tracks are up here in North Florida. And
but don't railroads contract with each other so that Norfolk Southern could use Florida East Coast or some other tracks to send their shipments?
They do, but at each step along the way, you're adding cost. So that argument sort of defeats what they're doing. If we have to go through all those steps to get grain to Central Florida via the Norfolk Southern. But here is the real issue there is the court is trying to balance the interest. And of course that would be correctable on appeal if the court made incorrect legal rulings there. what the argument really here is whether they've been denied an opportunity to make a record so they can come up to appeal. I think they use a comment, there will be a hole in the case. But that's simply not the case. What precisely Norfolk Southern's rates are, what they may offer to Columbia Grain, has nothing to do with whether there's a duty to mitigate. That only has to go with, once the duty is established, measuring it. And that's not an issue that they're going to need to make a record of to show later on. Let's assume the court does continue with its present finding that there is no duty to mitigate. The way you prove that there would be a duty to mitigate is for them to prove that the contract was exclusive. I submit that they're not going to prove that, but theoretically speaking, they don't need Norfolk Southern's rates to prove that. That's the party's testimony. And they're free to take depositions on that issue quite a bit. As a matter of fact, we, in our response, indicated where one witness was asked questions along those lines. In order to prove the reasonableness of the duty to mitigate, in other words, whether it's reasonable to expect Columbia Grain, after having spent $5 million in Central Florida, to come up in North Florida and build another facility right down the road from their current facility.
Well, maybe I'm missing something, but I mean, the fact is you are negotiating with Norfolk Southern. I mean, or you were at least, and so you thought that there was a possibility that you could economically do business, and you sat down and you talked with them, and now you're saying that for them to suggest that there was any way for you to mitigate, it's another one of those situations where we can just kind of skip over it and not really have an evidentiary basis for it because everybody kind of knows it.
There's a difference between having a duty to mitigate and actually doing something. For example, we may not have a duty to mitigate, but if we nevertheless take unreasonably costly and risky measures and do it anyway, and let's say we do, and again, this is up North Florida, but let's say we did truck grain to Central Florida, then obviously we can't claim as damages profits we didn't lose. I mean, that's going to come out in the damages calculation. In other words, any sales that we made to these entities would reduce any lost profit damages that we may be claiming. But as far as establishing the duty, the way you do that is you get experts, and certainly my client CSX are...
But your lost profits are measured in part by your cost, correct?
That is true.
And your cost is in part what you're paying Norfolk Southern.
Right. And at that point, if that occurred, they would be entitled to know our costs and that type of thing.
So
but
then
that's
they
different
could,
from
after the I guess this is at the damages phase of the trial, they're now going to have to engage in discovery. Is that your...
Oh, well, no, I mean, they would know that before trial. I mean, quite frankly, this trial is set in August. We can't build a train facility between now and August. But respectfully, I think there's a difference between a duty to mitigate, which is at issue here, and actually doing it. And they would be entitled to that evidence. Certainly, if we're out selling to a customer who we're claiming we can't sell to, they're going to be entitled to that discovery, having nothing to do with mitigation. That's just having to do with the damages. But here, what we're interested in is whether there is a duty to mitigate. And the way that is measured by the trial court is how costly is it to build a new train facility, those types of issues. And I would submit through the experts, in-house or out-house, however the parties want to do it. I see my red light popped on, so
It's been on, but I mean, that's okay.
I apologize.
No, it's up. You were answering questions. You can complete your argument. Sum it up if you want. Thank you. Mr. Gavin. You have 5 minutes left, Mr. Tanner.
Thank you, Your Honor. Just to touch on the point Judge Van Nortwick made, it is in the record here that they contract with FEC to ship down into Central and Southern Florida. So it is possible, and that's at page 24 of Mr. Owen's deposition. So that's in the record before you. And then the point both Judge Van Nortwick and Judge Hawks touched on, that is, what about the overall grain market? We submit the overall grain market is very much an issue in this case, and they injected it into this case through their promissory estoppel theory. Under the W.R. Grace case, whether a promise, which they allege was made, should be enforced by estoppel requires the court to examine the total circumstances of the parties, including whether the promise needs to be enforced in order to avoid injustice. And that's what they've alleged. They've alleged that the court must enforce this alleged promise to avoid injustice. And we submit then that if they were able to, or did, go out into the market and negotiate rates with another carrier, which would enable them to obtain the economic benefit that they claim they lost from us, then that would be a factor the court should consider as to whether the promise should be enforced to avoid justice. Certainly, we think we ought to be able to develop a record on that to bring to the court on plenary appeal. We submit in response to your point, Judge Van Nortwick, that it's very much their burden under the Moore case and the Nash case to plead a matter in avoidance. We have alleged mitigation as a defense. They have said essentially, no, that defense doesn't apply here for this reason that we think is unquestionably a matter in avoidance. It was their burden to plead it and then show it at the hearing by evidence, which they've done neither. The rates that are charged to others are very much at issue in this case. What they're saying in this case is, we expected there to be a spread between the rates that you charged us, meaning Columbia Grain, and the rates you charged all of your other customers. So the overall grain market and what other customers were being charged and paying is very much an issue per their own allegations. Put aside the anti-competitive issues that are involved in that. But that's their allegation. And so we submit that the overall grain market and what they could negotiate with other carriers is very much an issue in this case. I would agree with your point also that negotiations can be a trade secret, certainly, under the Fujitsu case. But again, there needs to be a showing. And under that case, the court allowed disclosure of those pursuant to a protective order. Because there was a necessity shown for the information. And we have a protective order in place here. It's been in place for over a year. And
what about the argument that the Norfolk Southern entire deal falls apart because Norfolk Southern has absolutely no confidence in the protective order? In other words, they walk away. They say this protective order, it might be great for you guys, but we're not involved in the case and we're not relying on that.
I understand your point, Judge. If there was a witness who came into the hearing and so testified so that there were no other rates to compare with, then so be it. If there was an affidavit or a deposition to that effect so that there is no other arrangement that we could point to in mitigation, then those would be the facts. But our quarrel, again, is that nothing of that sort was shown here. And so we think that we would ask you to quash the order, send it back to the trial court to have a hearing, be it in camera or evidentiary or whatever the trial court wants to do, make them bring forth the information, have it reviewed. If they want to claim that, if they want to bring in the kind of point that you made, Judge Hawks, bring in a witness. And then, if it is a trade secret and it's relevant, and we submit clearly it is, but if it is relevant, have it produced pursuant to the protective order and the attorney's eyes only provisions in there. And that would be an adequate balance of the interests of the litigants here. It would enable them to protect their confidential information, and it would enable us to develop a record on not only an issue in their case, that is estoppel, but also the mitigation defense, so that if we get to this court again on plenary appeal, there'll be something for you to review. Otherwise, there won't be anything for you to review on those issues. So, unless there are any further questions, I'll sit down.
Thank you.
Thank you, Your Honors.
We'll be in recess until 9:45, any attorney comments.